Court calls case People versus Combo Carter.
Before we even dive into this one, buckle up, because what you're about to witness is a prime example of how courtroom patience gets tested to its limit. This isn't just another defendant before Judge Simpson. This is a man stacking case after case while trying to convince the court he's misunderstood. Today, the spotlight's on Mr. Carter, a name that's quickly becoming a regular on the docket. He's back for a probation violation, a pending felony, and now a brand new domestic violence charge. Judge Simpson, known for his firm yet fair demeanor, has seen this man before. And the tone in court shifts instantly when his name is read. The courtroom energy says it all. One more misstep, and patience might finally run out. What makes this hearing fascinating isn't just the legal tension, but the human pattern underneath it: denial, repetition, and the slow erosion of trust. Here's the question: how many second chances can one man burn before the system says enough? Stick around. This case will answer that better than any lecture ever could.
Honorable Carter, David Burgess, on behalf of Mr. Carter.
Kamau Carter. Thank you.
Chris Clare on behalf of probation. Your Honor, Mr. Carter is before the court for an adjourned violation of probation. Mr. Carter, when he was last before the court, did have a pending felony case. The court did arraign him on that bench warrant. He was set for court. That case that is pending is now set for appeal on November 5th. Mr. Carter now has another new pending case, a domestic violence second offense, and it interfered with communications with an alleged date of offense of October 20th, 2024. He is on bench warrant status in that case. Given that there has been continued alleged assaultive behavior with the added victim in this case, because the court did add a no contact with that victim, it does make it a violation of this case. Probation's asking that the court, one, address the felony warrant on that 2-4-FB case. If the court does have it, that the court revoke probation and sentence Mr. Carter to jail 365 days, credit for 162 days served to serve the balance, that he complete the jail DV program, waive remaining terms, accepting his financial obligations, and discharge him from probation without improvement.
Mr. Burgess.
And Your Honor, I believe he's been arraigned. Well, obviously he's been arraigned. The PE is scheduled for tomorrow morning. I believe.
This is where things start to unravel in real time. The defense attorney's confusion says it all. He's just realizing there are new charges on top of the ones they came in to handle. That's never a good sign. When a lawyer says, "I was unaware there were new charges," that's like finding out your client's been writing new chapters to a story you're trying to close. The tension rises subtly. Judge Simpson, stone-faced, allows the attorney to stumble through the procedural mess. 2 charges now sit on the record: interfering with an electronic communication device, a felony, and domestic violence second offense, a misdemeanor. This moment is critical because it highlights a recurring legal issue: defendants who underestimate how fast violations stack up. Carter's situation is textbook. One unresolved case collides with a new one, and the courtroom suddenly becomes a maze of overlapping bonds, warrants, and restrictions. Who's really losing control here? The system or the man standing before it?
On the one case, I have a new case, however.
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client on those charges.
I am.
Okay.
And I don't know. We're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already. So.
It's a charge of interfering with electronic communication device, the 2-year felony, and then also domestic violence second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, You want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court.
Now comes the defense's desperate play, bond negotiation. This is where defense attorneys earn their paycheck. Mr. Burrs, trying to humanize his client, leans hard into sympathy. He just got a new job, Your Honor. But in Judge Simpson's courtroom, employment doesn't outweigh behavior. Then comes a classic defense twist. The same victim across both cases doesn't want to testify. That's a major curveball. In domestic violence law, this happens often. Victims recant, withdraw, or go silent. The defense knows this weakens the prosecution, but the judge knows it doesn't erase what's already on record. It's a tug of war. Emotional appeal versus legal responsibility. Carter might be trying to show stability, but the pattern of repeated contact with the same victim paints a different picture. The courtroom's silent calculation is chilling. Does mercy risk enabling the same cycle all over again?
Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honors, indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So later, and I will tell the court after review of the police report, the person representing themselves to be the defendant, they have contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the police officer was speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back or presented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the scope for probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation about the probation and sentence the defendant to serve balance at this time. And in bond in this case, we're asking for $100,000 for the new felony.
This is the breaking point. The prosecutor drops the bomb, a $100,000 bond request. That number isn't random. It's the justice system's way of saying, we're done gambling on your self-control. The prosecutor's delivery is calm, surgical, every word meant to remind the court that leniency hasn't worked. He points out a critical contradiction. Carter admitted contact with the victim even after being told not to. That single admission turns the courtroom from lenient to lethal. Once a defendant acknowledges violating a no-contact order, judges have very little room left to show leniency. Carter's legal standing just collapsed under his own honesty, and the audience can feel it. The air thickens, the tension spikes, and even Carter's lawyer knows this might be an uphill climb from here. If you were the judge, would you take another chance on someone who can't follow the simplest order?
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana, that the defendant will submit to random drug test when requested. He's not to leave the state of Michigan without permission of the court. You're not to possess, purchase any firearm or ammunition or other dangerous weapon. You're not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are to have no contact with Jennifer Matlock except by a civil standby with the police. You cannot have any direct or indirect contact with the above named person, Miss Madlock, in person or through others or by electronic communication, including but not limited to phone, email, texting, internet, social media, or refer to the person listed online in any form whatsoever. You are not to go to I have a location at 1265 Russell Street.
Okay, I'll check that, Your Honor, while you continue and double check that that's correct.
You are not to go to that location except with civil standby with the police. If this is your home address, you must find another place to live and notify the court of your new address within 24 hours of any release from incarceration. You are not to violate any criminal law. You are to personally appear at all court hearings and other places as directed by the court. You understand all of those conditions?
Yes, sir.
And Your Honor, that address is the location where the incident took place. If we'd also ask the defendant be prohibited from going to a Glencoe Hills address, but I can give the court whenever it's ready.
Yes, go ahead.
22, well, actually, we just request the Glencoe Hills apartment complex in general, specifically 2252 Glencoe Hills Drive in Ypsilanti.
225.
2.
Better, I'm not entirely sure what is going on with you in that regard.
Not litigated.
I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't. But
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
This is where Judge Simpson finally lets the frustration surface, not in anger, but in principle. When he says, "I gave you a break the last time," it's not just a reprimand, it's a record. Judges keep mental ledgers of leniency, and Carter just overdrew his balance. The defense tries to paint the encounter as harmless. She came to get her phone, but Simpson's not buying it. In domestic cases, just contact often spirals into risk. The judge sees the pattern, defiance disguised as misunderstanding. And here's the beauty of Judge Simpson's delivery. He's not lecturing, he's dissecting. Each word slices through excuses until only accountability remains. For viewers, this is a masterclass in judicial restraint and controlled authority. How many times can a judge show patience before it becomes complicity? That's the razor edge Simpson's walking right now.
Simpson, can I say something?
You can say whatever you want.
I understand. She put up on me. I was in the room playing my game, and she came in the room. And
Then you get up and leave.
tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car and that's when I pulled off.
Well, maybe that's all gonna come out, Mr.
I
Tom
understand.
Carter. Maybe that's all gonna come out. I let you out the last time. Should have of all rights locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? I end up, you get that other case set for exam. Then what ends up happening? I get here and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety on his other matter. Anything you want to say before I post sentence on that case?
I want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. I understand it. When I get out this situation this time, I'm be by myself.
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on a $100,000 cash bond, and you're about to go now.
The moment those words leave Judge Simpson's mouth, "You're about to go now," the entire courtroom shifts. It's the unmistakable final act of authority. The gavel hasn't even fallen, but everyone knows the sentence is sealed. This is the instant accountability meets reality. Carter's face says it all, defiance turning to disbelief. But Simpson's message cuts deeper than punishment. He's drawing a line between self-sabotage and consequence. His tone isn't personal, it's procedural justice in motion. Legally, this ruling makes sense. Probation revoked, bond high, behavior consistent with non-compliance. Emotionally, it's the system saying, you've been warned, again and again, and still chose chaos. If you were in Judge Simpson's seat, would you still have offered one last chance or made the same call? Drop your thoughts. This one divides viewers every single time.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
And Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Don Farm program. Probation also requested the DV program. I think they just requested DV. The court want the defendant to perform both or just one or the other?
I should have said in-jail DV program is what I meant to say. Thank you. Defendant's remanded. That's not before me. He's got to do it in circuit court. Court calls the case People versus Maurice Couchman.
After one for the people. Couchman, please state your name.
Maurice Couchman.
Okay.
Now, a new case enters, but the atmosphere hasn't cooled. The next defendant, Maurice Couchman, brings a completely different energy. Quiet tension, emotional restraint, and a familiar story. Relationship complications spilling back into court. Judge Simpson transitions smoothly, proving once again that courtroom management is part art, part endurance. The introduction of a new defendant immediately resets the tone, from confrontation to control. Couchman's case contrasts sharply with Carter's: compliance, cooperation, and visible remorse. But there's one twist. The victim in this case, Alyssa Chamberlain, is appearing via Zoom to request a lifting of the no-contact order. That's a legal grenade. Judges approach these requests carefully because behind every reconciliation is the risk of relapse. So, as the scene unfolds, keep your eyes on Simpson's face. This is where empathy meets caution.
Teresa Clare on behalf of probation. Your Honor, it's my understanding that the victim in this case, Alyssa Chamberlain, should be present via Zoom.
Alyssa Chamberlain?
Yeah, I'm here.
Okay. Yes, she's here.
So, Your Honor, it's my understanding that Ms. Chamberlain would like to address the court to request the court lifting the contact order. Does the court want to address that first, or my recommendation for Mr. Couchman?
Either way, go ahead with your.
Okay. So as to Mr. Couchman's recommendation, he is compliant with the terms ordered by the court. I did make his appearance, however, he is present today. Probation is recommending that all conditions continue as previously ordered, with the next review hearing being set February 10th, 2025 at 1 p.m.
Sir, anything you want to say?
I know she wants to take the order away or whatever. I want to keep it.
Okay, so hold on. Ms. Chamberlain?
Yes, sir.
All right, do you have a camera?
Yeah, you want me to turn it on?
Yes.
Okay. Hello.
Hello.
Hi.
All right. What did you want to tell me?
I just wanted it lifted because I've been in contact with his mom to see our son Leo, and she hasn't really been compliant with it.
You've been in contact with whom?
With Maurice's mom.
Okay.
And she hasn't really stuck to her things or anything like that. The last time I was supposed to pick Leo up, she completely ghosted me. So I was just hoping to maybe lift the no contact order to just talk to Maurice directly, but just about our son.
Okay. And thank you. And you have a problem with that?
Yes, sir. Yes,
All right. Hang on before you go.
People would be opposed to any change in the no contact order this time.
All right.
It's my understanding from probation that probation, I don't know if you're taking a position or not, but people wouldn't be opposed to it.
All right. Sir, what did you want to tell me?
I just want to keep it like it is, no contact.
This moment captures the quiet heartbreak of courtroom reality. Maurice, the defendant, speaks softly but firmly. He doesn't want contact, even though the victim is asking for it. You can almost hear the fatigue behind his tone. This is one of the most emotionally complex exchanges you'll ever see. On one side, a woman asking for a chance to communicate just for their child. On the other, a man who's learned that proximity often leads to chaos. Both are valid, both are tragic. Simpson steps in with surgical calm, clarifying facts, confirming arrangements, and probing inconsistencies. This isn't just about emotion, it's about risk management. Every decision here carries legal and personal consequences. Audience reflection. In domestic cases like this, should judges prioritize emotional healing or absolute safety? Think about it before you decide. The balance is razor thin.
You want to keep the no contact in place?
Yes, Your Honor, because I don't know if you were been told, but there was an incident a couple weeks ago. Her and her mother came to my house, and basically how I have it set up is my mom is supposed to make contact with her, and the last time she tried to make contact, she said she was going to pick the kid up at 4. She never picked my son up. She just ignored my mom. Alyssa Chamberlain.
Okay,
So,
go ahead.
she came to my house.
Who did? When you
Alyssa
keep
Chamberlain.
saying she,
I'm sorry,
I'm just
I'm
trying
sorry.
to. It's okay.
Alyssa Chamberlain
Just
Right.
nerve-wracking. Alyssa Chamberlain came to my house with her mother with the no contact. She's not supposed to be around me. I told her that. I called the police and made a police report. There's no reason for her to talk.
Okay, so hold on a second. So, because I just want to make sure I understand. The arrangement was set up that your mother would act as a go-between, basically.
Yes,
Is that right?
yes.
Okay. And then for whatever reason, something happened where you're claiming Ms. Chamberlain did not get the child from your mother. Is that right?
Yep.
And then 2 weeks ago, you're saying thereabouts,
Yeah.
that Miss Chamberlain and her mother
Yes.
show up at your house
Yes, Your Honor.
and that you ended up calling the police.
Yes, Your Honor.
Hold on. Ms. Chamberlain, is all of that correct?
So kind of, it was me and my aunt, and we did show up at his mom's house. But at this point, I didn't know that me and Maurice had a no contact order. I wasn't aware of any of this. I moved and didn't receive any paperwork. I changed my number, so I wasn't receiving any calls or anything. So what happened
What do you
was,
mean? What do you mean that you didn't know?
I didn't know there was a no contact order.
So
I didn't even
why
know
do you-
Maurice
why
got in
do you-
trouble.
Hold on. So why do you think you were why was his mother then acting as a go-between?
I just thought he didn't want to talk to me.
Okay. So it sounds like he still doesn't want to.
That's okay, but we need to figure something out to where his mom answers the phone and sticks to her stuff when I'm supposed to pick our son up.
Okay, so I'm going to assume that his mom,
Yes, sir.
I take care of.
hold on, that she's a full-grown woman, and so are you, right?
Yes.
So it seems like for your son, her grandchild, that the two of you could talk to try to work out whatever you guys want to work, and that Maurice doesn't necessarily have to be a part of that, does he?
I mean, no, and it wasn't a problem until the last time when I was trying to get Leo. She told me I could get him, and I confirmed it the day before and then completely ignored me. So then that's when me and my aunt went to her house to try to talk to her. I didn't know Maurice
Right.
lived there.
Okay. So here's what I'm going to do, because there's obviously something else. I'm not entirely clear what's going on, but if he got into a circumstance where he had to call the police.
Judge Simpson has seen this story too many times. When he says there's obviously something else, he's not guessing, he's diagnosing. He senses what most viewers overlook: emotional confusion disguised as custody conflict. His decision to maintain the no-contact order isn't punitive. It's preventive. Too often, reconciliation under unresolved trauma reignites the very patterns that brought people into court. Simpson's restraint here is wisdom forged from repetition. Notice how he steers the conversation, not toward blame, but toward boundaries. This is judicial counseling at its purest, guiding two volatile lives toward legal structure before they implode again. For viewers, it's a subtle lesson. In family-linked domestic cases, stability isn't found in emotion, it's enforced through order.
Then that circumstance can't happen. So I don't know what is going on, and you guys as parents need to figure this out for your son, quite frankly. But as between the two of you, if he doesn't want to have contact, I'm not going to force him to have contact. I mean, he's relying upon the court's order, and he did, quite frankly, given the other hearing I had today, he did exactly what he was supposed to do when you showed up. He wasn't trying to do anything. He called the police because he's the one under the jurisdiction of the court. But if he doesn't want that, I'm not going to change anything.
Okay.
And for the record, Your Honor, I asked probation if there was currently a circuit court order regarding parenting, and there is not. And I understand
Okay.
the defendant has custody of the child this time,
Who does?
the defendant,
You have custody.
yes.
I do not have like
Hold on.
legal custody, but I've been taking care of my son for the last 8 months, taking him back and forth to school, everything.
Okay.
So
I'm
Now
just
you're
being,
giving-
No, I got you. I
now
gotta
you're
get
giving
that.
everyone legal advice about what to do, but
Well,
There's no-
somebody's gonna have to figure, yeah. You guys are gonna have to figure something else out. But, ma'am, Mr. Couchman does not want contact with you directly. So I'm not gonna place him in a position where he has to do that. Because obviously he's maybe through this process learned something. So, I'm just gonna leave everything where it is. I'll continue all of your, Mr. Couchman, I'll continue all of your previous terms as ordered.
2 cases, 2 outcomes, 1 courtroom philosophy. Judge Simpson demonstrated why his courtroom draws attention nationwide. Accountability paired with humanity. David Carter's downfall was built on defiance. Maurice Couchman's restraint was built on reflection. Both show how the justice system walks a line between compassion and control. From revoked probation to protected boundaries, today's hearings prove that personal change means nothing without consistent action. The courtroom isn't just about punishment. It's a mirror, showing defendants who they really are when excuses fall apart. If you found this case as revealing as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns right here on Trial Truth, where real justice meets real emotion.